Hey, good afternoon, everybody. Is everybody in, Ashley? I can't tell when I'm sharing my screen.
Everybody's in. You're good.
Everybody's in. Okay, good. See, we're real casual here. We're just sitting, relaxing. You know, me and Ashley. JR is all business-like. They're in his office. But we're just real casual here. And we're about to tell you about what's up with us, not us personally, but with the real property law section of the California Lawyers Association. Give you some really good, useful information today for your legal life and for your personal life. And why don't we just jump right into it, okay, guys?
Sure.
Let's do it.
All right. So we're gonna introduce, well, as we have our usual crew, although we're going to be changing up a little bit going forward, and we changed up a little bit last month. I'm Neil Kalin. Welcome, everybody. We have Ashley Peterson, and we have JR, John Richards, here with us. What are we going to be talking about today? Well, we're going to start with the CDC Eviction Moratorium, the Centers for Disease Control and Prevention. Their eviction moratorium that started in September of last year. There have been a few interesting court rulings addressing that moratorium, so we're going to start with that. Then we're going to change gears a little bit, and JR and Ashley are going to talk about what it's like being a solo practitioner and how you get started and resources that you need to make your law practice a successful and not all consuming. That would totally just takes all of your time away from anything else that you want to do. So there we go, hints for setting up, operating, and becoming a successful solo law firm. And then we're going to jump into a couple of interesting cases, one sort of related, which is personal liability for debts of a corporation. So I assume Ashley and JR will kind of tell us about some of the possibilities about how to set up your own law practice, and whether that involves an entity or not. And then we're the real property section. So that I thought there was an interesting case about home protection companies and whether they are insurers or not for purposes of bad faith and unfair competition laws. And we'll end up just showing you what we've got coming up. Hopefully you'll join us. And as usual, if anybody has any suggestions or ideas or input, we'd love to hear you, and we'd love to see you all next month as well. So let's get started. Well, again, here's our cast. I already introduced you, JR, me, and Ashley. And last time I was here, which was 2 months ago, I kind of made fun of Ashley May and compared her to Ellie Mae of the Beverly Hillbillies. And Ashley reminded me that really I'm the cowboy of the group of us. And I said, well, no problem. I'll get my photo with me in my usual cowboy outfit, my boots and my blue jeans and my hat. And I was looking for one, and you know what? I had trouble finding one of them. So this is the best thing I could find. There you go. And
nice, Neil.
I know somebody's going to have to teach me how to do those, things a little bit better. But there I am.
That's some excellent photoshopping skills.
Yeah. I'm gonna take a week off, I think, and practice some photoshopping skills. So I'll do that a little bit better for you next time. All right.
It's like the cartoons in what is that? Oh, shoot, South Park. You know, where they just put on top of it.
There we go.
Yeah.
Yeah.
That makes me sound much better when you compare me to South Park, so I appreciate that. All right, so let's go ahead. Let's talk about the CDC eviction moratorium and some of these cases that have come out. And what we have now, we have a split in the Fifth Circuit. There's 2 district courts in the Fifth Circuit that have come out with conflicting opinions as to the enforceability of the CDC's order. And one is Turkle versus CBC, the other is Chambliss Enterprises versus Redfield, which is really against the CDC. And I'm going to read from a couple of the introductory paragraphs. And so you can guess, which court sided with the CDC and which against the CDC. So the Chambliss court, in one of their introductory paragraphs says, the US is affected by a global pandemic. which has infected tens of millions worldwide and resulted in the deaths of more than 280,000 people within our borders. Now, this case came out in December of last year. The CDC implemented a temporary eviction moratorium to prevent the further spread of COVID-19. This case was decided procedurally as a preliminary injunction. The Turkle case, which came out this year, said, this lawsuit presents the question of whether the federal government has the authority to order property owners not to evict specified tenants. The federal government claimed authority to suspend residential evictions for any reason, including an agency's view on fairness. And this case was decided on summary judgment, not at preliminary injunction. So which one do you think decided for the CDC and which against the CDC, Ashley or JR?
I'm going to say the state court obviously went against this, and the federal court went with it.
Well, the Chambliss or the Turkle court. So they're both federal courts. They're both federal district courts within the Fifth Circuit, the federal circuit.
Oh, I see.
JR?
I'm sorry. Yeah, the
Okay.
Louisiana court went with it. Texas court went against it. Gotcha.
Okay, there you go. And that's right. We've got one in Louisiana and one in Texas. So that was another hint there. And so, and you're absolutely right. You're absolutely right, Ashley. So let's take a quick look at some of the substance that was involved. The facts really are the same for either of these cases, which is in September of last year, CDC issued a eviction moratorium initially through December of 2020. And it's been extended through March of this year, the end of March of this year. So just 2 short weeks away. What happens here, a residential tenant, if they provide a declaration under penalty of perjury that they are unable to pay rent for a COVID-related reason, then the landlord cannot evict them during this period of the moratorium. Only applies to residential tenants whose incomes are below 100,000. I think it actually says 99,000 or below. As in all the cases, the plaintiffs are individual landlords and apartment associations that represent them. And so what happened here? What happened in the Chambliss case? Well, the issue was, again, it's a brought on preliminary injunction. So the legal approach was, is there a substantial likelihood of success? Is there irreparable injury to the plaintiffs, the property owners? Does the injury outweigh the harm that would happen if the relief was granted? And is there no disservice to the public? And so if you look through, I'm not going to read through the whole district decision there, but something that I think we have to, pay attention to and look down there at the bottom. This is primarily a statutory case, not a constitutional one. And the plaintiffs, the property owners, failed to satisfy their burden of proof. Interesting that they were focusing there on compensation and the losses are compensable. Of course, the landlords are saying that's just a fiction because there's no way we're going to be compensated. If people can't pay their rent, there's no way they're going to be able to pay it after all that back rent, after the moratorium is over. But that's how this court looked at it. Now we look at the Turkle case and it looked at it a little bit differently. It's looking at this case from the viewpoint of the Commerce Clause and whether the Commerce Clause allows regulation, or says the Commerce Clause allows regulation of activity that has a substantial relation to interstate commerce. So they're not focusing on the statutory authority, they're focusing on the constitutional authority. And something that I thought was very interesting is while the Chambliss case looked at, well, we're just talking about a compensable, potential injury. And the Turkle case talks about, well, wait a minute, this CDC order makes it a crime of up to a year in prison if you evict a tenant that's provided this declaration. And this is not just some minor compensable injury. You could be fined of up to $250,000 too. So in other words, they're approaching it in a much more substantial way. And look at the last couple of lines there. Although the COVID-19 pandemic persists, so does the Constitution. summary judgment was granted for the property owners in this case. But interesting, the court said, we're not going to issue an injunction. We just expect the CDC to follow our rule. Of course, the CDC has appealed that, which means it's going to go up to the Fifth Circuit. How soon and when is another issue.
How does the CDC have legislative authority like this, like to make this type of a law that would be federally and uniformly applied? Like that seems like an overreach of their powers, right?
Well, potentially. I'm going to go back a screen. So if you look at kind of the third underlying part, the district decision, it mentions where the federal authority comes from.
Mhm.
So the United States Code and the Code of Federal Regulation, and then it was a matter of interpretation. Is the CDC acting within the bounds of what the statute says? Okay, so there is actual authority. Does it say you have the authority to issue an eviction moratorium? No, the CDC says that flows from the authority that they were given pursuant to the United States Code and the Code of Federal Regulation.
And I guess the other question too is like how that would interplay with state eviction moratorium laws, because this is completely different. It's federal. So how does that interact,
Right. And both cases were very clear that these lawsuits do not impact in any way whatsoever the state's ability to enact their own eviction moratorium.
I think that there's a lot of interesting questions here that may not get answered for 4 or 5 more years because, for example, in California, what really gives the governor the right or the executive power to issue the moratoriums that he did? And in retrospect, is there legislation going to go through that does try to limit either the federal government or the executive branch of the state government from doing these things in the future? I think we're going to have some interesting legal fallout from what has happened here.
Well, I agree. And one of the issues, I just for those of you who want to take a look, I imagine, and we've got, I think these are hosted on the Real Property Section website. Do you know if that's true, Ashley? These What's Up With Us seminars?
Yes, they should be on the website.
Okay. So if anybody wants to look at some of the differences, and maybe that explains why there was different interpretations of and different conclusions by the court. But something that I put down here is, well, at least as of now, the CDC moratorium expires in 2 weeks. And so the issue will be, well, I said, well, the CDC appealed the Turkle decision, so up to the Fifth Circuit, but is that going to matter? Because if it's expired, is the whole issue moot? And if the whole issue becomes moot, that kind of raises the issue that I think you implicitly raised, JR, which is, well, then are any of these government authorities ever going to be able to be contested? Because if it takes a year to get through the process and the courts just say, well, the year's up and none of this matters anymore, then there's nothing to stop the same thing from being repeated in the future. Again, obviously people have different views of whether it should be allowed, whether it's good public policy or bad public policy, but the courts don't seem set up to handle a situation if it takes so long to get a decision that has more impact than just upon the 2 parties to the particular case, right? Because that's how trial courts really impact, is just the parties to that particular case if there's no widespread injunction that's been issued. It's something I just wanted to I bring up that I thought was interesting. The CDC issued guidance because there was a big issue when they first issued this order, which is, wow, can a landlord even serve a notice to evict a tenant? What if the tenant lies in their declaration under penalty of perjury? Is that stuff even contestable? In California law, by the way, the California Eviction Moratorium, there is no process to even contest the tenant's representation that the tenant has been impacted for a COVID-related reason. None whatsoever.
Right?
Huh?
High income.
Yeah, so there's somebody talking about, or whether they are below or above the threshold of the income, right? And so at least in the CDC guidance, they said, well, you can contest the truthfulness of the tenant's declaration, and the landlord can go through the entire eviction process, but cannot actually conclude the eviction during the moratorium. So they can kind of prepare themselves for the end of the moratorium. And again, this is only going to affect those states that have not enacted their own eviction moratorium like California has. Something that just came out, I just saw a notice about this yesterday, so I thought I would mention it. There's a decision out of the Sixth Circuit, again, the district court out of the Sixth Circuit, called Skyworks. It is based on a preliminary injunction, and it is based on the statutory authority, not based on the constitutional authority. It reached the opposite decision of Chambliss, right? And said the CDC exceeded their statutory authority. It distinguished the Chambliss decision. I thought I would just read a couple of sentences from that. So let me get to that part. Give me a minute. Without question, effective pandemic response depends on the judgment of reliable science, not political science. But that obvious truism does not empower agencies or their officials to exceed the mandate Congress gives them. The Chambliss decision has the feel of adopting strained or forced readings of the statute, stretching to rationalize the government policy at issue. That is not a proper methodology of statutory interpretation, nor is it the proper role of the courts. So very different, a very direct sort of rebuke to a sister district court in a neighboring circuit. So again, we'll see what happens with all this stuff. We'll see, if there's appeals, if the appeals are just dismissed as moot in 2 weeks. So I thought that was an interesting issue for our members, and they might be interested in following up. And again, I put down the way to identify cases if one wants to look them up. Are we ready to talk about solo practice?
Sure.
Okay.
Do it.
All right, good. So by the way, when I'm sharing my screen, I have a hard time seeing if there's any comments coming in, so I will trust either Ashley or JR to bring up comments if somebody raises them.
We'll keep
Yeah, we're on it. And
Okay,
I
great.
misspoke, Neil, earlier. The videos are actually all on the Real Property YouTube page. So if anyone wants to go back and look at that, I put the link in the chat box right now for anybody who wants it.
Okay, thank you. Well, that's good for me to know, because I didn't know exactly where they were being hosted. So that's
We're
great to
trying
know.
to get them put on the website as well, but that hasn't happened yet. So.
Okay, so the Real Property YouTube page. Good to know.
Yes.
Good to know. All right. So I'm going to turn the mic over to Ashley and JR, and you let me know when you want me to change the slide, okay?
All right. Thanks, Neil.
Hey, Ash, I have a little intro that I wanted to do. I wanted to alert everybody to 2 things. So there's a solo small firm summit. It's all online this coming summer, June 24th and 25th. The CLA is conducting it. So this part inspired by that. And then the other part of why we're inspired to talk about solo and small firms is that because of COVID, a lot of people are kind of breaking away from, the law firm structure. There's a lot more people going solo. So Ash and I happen to both be solo practitioners, and we wanted to share with you some of the, Beth just posted the solo small firm summit information for you. It's down there in the chat. But anyway, this is in part inspired by both of those things. We've gone through the grinder and done it ourselves. So we have a few things to share with you. Ash?
Yeah. So JR, you want to talk about what made you decide to go solo?
Yeah. So, my case, so there's 2 reasons that, there's a couple reasons why you might go solo. But in my case, I was pretty much forced to go solo. The firm I was working for was kind of wrapping up business. Their business model was kind of deteriorating, and they were shrinking. And it also happened to be a time when the economy wasn't growing very well. So I basically had to go out on my own. Some people, I've actually talked to a few that actually chose to go out and go solo themselves. How about you, Ash?
How many years are you out, JR, solo?
So I went solo in 2011, almost, about 8 or 9 years.
Yeah, so I went solo 2015. So I made that decision because the firm that I was at was not the right work environment that I wanted to be at long term. And I sort of was kind of having a quarter life crisis, trying to figure out what to do with my career. And some colleagues started sending cases my way when I was in between jobs. And I was thinking to myself, well, why can't I just take some of these cases on? So I got malpractice insurance, and then it's steamrolled from there.
So you touched on exactly what one of my main points is in the decision to go solo. And that's kind of having an idea of what your customer base is and where you're going to get customers from. If you feel like you have 2 or 3 strong clients, cases, that's an opportunity. And is that what you did?
Yeah, I wanted to create an environment where I could control, the client management side of things. I got to pick which clients I was working for, what types of cases I was taking on. And when you're at a firm, obviously you don't get that discretion at all. So I also was not really a fan of the billable hour requirement. I think that that's such a difficult thing that is perpetuated in the legal community. And I think it also promotes unhealthy lifestyles. It promotes super stressful situations. People are worried about losing their jobs every month if they don't make their billable hours. So for me, being solo and not having to worry about that has been a huge weight off my shoulders, and having the flexibility to take time off and go on vacation when I want, that's been so huge for me.
Well, so one of the things that occurred to me when I was working in the firm is I was billing at this rate right here. But if you looked at where my paycheck was in relation to my billable rate, it was really about that much. So there was all this overhead here that I was making for the firm, but I was not receiving the benefit from. So even working solo, you take away a lot of that overhead from the process. You make more of the money that you're actually making. So it's kind of cool. Yeah.
What are you I'm a sole proprietor. Are you incorporated?
I'm a sole proprietor as well.
Yeah.
Thought about becoming an LLP, things like that, but I'm still maintaining sole proprietorship.
Yeah, I never did the corporation route to do a PC, professional corporation, because I didn't have any employees, so it didn't really seem necessary. But I know a lot of people choose that route, or if they open up with a business partner doing the LLP. So
JR and Ashley, how do you get some administrative type work done? Do you do that all yourselves? Do you hire independent contractors? What do you do?
I mean, I was doing everything by myself except for the accounting and tax stuff, which I don't touch with a 10-foot pole. So I have an accountant who does all my profit losses, and I just send her all my invoices and bank statements and things like that monthly. And she prepares those for me and figures out what my quarterly tax reportings are. But as far as like paralegal stuff goes, I do that all myself.
Okay.
So again, after 8 years, I recently hired an assistant who does the paralegal stuff for me. She's full-time now, but for the last 8 years, I did it all. Like I literally, when I went solo, I did not know how to fill out a summons. Like my first filing I had as a solo was rejected because I didn't fill out the summons correctly.
Yeah.
Part of because you never learn that. I mean, where do you learn that?
Right.
I'm at the point where I'm like, finally, I mean, I'm getting so many calls in a week that I just don't have time to take every single call. I don't have time to return everyone's calls. And I'm literally just referring out like on a daily basis, 90% of my calls that are coming in, because I'm just at capacity right now. But I'm right now in the process of transitioning to get a virtual answering service to start taking my calls from my office and doing the messages, and then they're going to be able to do the return calls with the referrals from me. So I'm hoping that that will save me a lot of time, because right now that's taken up a huge chunk of my day.
I would concur with that. Everybody who is a true solo, you have a hard time balancing actually getting your motions, writing your drafts all done, and developing business at the same time. You know, invariably out of 10 calls, maybe there's a percentage of those that are going to be, you can actually help them, or, you know, that it's a good fit, you know, or they can actually afford you, things like that. So there's a kind of weeding out that happens. But if you're spending 2 hours a day talking to new people, you're wasting a lot of time that you should be billing. So what I was going to say is, did you market your firm, or did you form your firm like cat off of another firm or anything like that, Ash?
No, so I worked with a web designer in creating my, what is that what you're talking about for like the website stuff? Or are you talking about just the structure of the firm?
Like the structure of the firm, like, you know, so what I did is I went and I shopped around other law firms, and then I basically copycatted them on kind of, you know, what I was doing. And I stole ideas basically, you know.
No, I think I sort of did everything myself.
So I just want to tell our audience that JR and Ashley have really different types of practice. So Ashley, if I'm right, you don't do any litigation at all. You're completely transactional, whereas JR, you have a mixture of transaction and litigation. So those who are thinking about going solo, they're in a firm, maybe they're not happy. There's really different approaches. You don't just have to go one way or the other. I think the two of you show that there's a wide breadth of legal approaches that you can take to your solo firm.
Totally. And I think honestly, having the diversity that I provide in my legal practice has been what's kept me alive, even through times where certain businesses are, you know, on the downfall. Like right now, obviously commercial real estate's down, and that used to be a huge chunk of my practice, but residential stuff is up, and I do a ton of residential stuff. So having that diversity, I know a lot of attorneys will do maybe one or the other, but won't do both. I also do like business contracts and formations for real estate holdings and stuff. So having that variety has really kept me alive, you know, as long as it has, and kept my successes going.
Well, so that was another tip that I had too. And Ash, I'm glad you touched on that. Is it's important for people to have a focus on kind of where they, like almost like a business model of what they want to do. I mean, it's amazing that you're able to do really transactional work. And you're really busy, and that's awesome. I mean, so for me, that's why I kind of do a balance. And in fact, even though that you should have a focus, I recommend trying new things too. For example, I got my broker's license. That's how, one of the reasons why I interact with Neil a lot is I'm actually a real estate broker as well.
Yeah. What do you do for marketing and getting new clients, JR?
That's a good question. So my first tip would be is to go to every single website that refers attorneys, whether it's Avo or Yelp or Westlaw, whatever it is, and at least get a profile up there and make sure that you have a web presence. So first is you got to have a website, but two is you have to have a web presence, which is a lot broader than that. And then three is, you know, I actually never paid for any advertising for a long time. And so I recommend, as somebody really embarking on being a solo, is don't spend any money on that, you know, for a while until you can really afford it. I don't know. How about you, Ash?
Yeah, I'm the same. I have never paid for marketing or advertising, and I get probably 3 to 4 calls a day from just my website or internet searches, which is pretty awesome. So building up your website and that SEO presence is going to be extremely important for any solo attorney, because that's what gives you the credibility. It's what pops you up in the Google searches if they type in real estate attorney in San Diego, for example. But yeah, like you said, claiming all those free pages is going to be huge. And I do have to say, like, my blog posts on my website have been what generates the most amount of traffic to my website. So if you post articles on hot topics or things that you focus on, people are craving that knowledge and information, and those have been a huge resource for me.
I agree, Ash. So for example, on Avo, there's a way to post answers to questions. I instead would recommend posting your own blog on your own webpage, answering some of the questions you see in places like Avo, because it'll help steer more traffic to your actual webpage, if that makes any sense.
Yeah, that's a good point.
Yeah.
Neil, you can go to the next slide and we can talk about case management and business operations stuff.
Okay, I just want to ask you one other question about promotions, and we'll see. This is not
Yes.
really a plant. We have some administrative help from the CLA, the California Lawyers Association. But have you received, as a solo, any benefit from your affiliation with CLA or the real property section? Has that helped you at all? Have you gotten any referrals?
Yeah,
from
I
clients?
mean, you guys know me, I'm super involved in lots of things all the time. So I have been involved in the Lawyers Club, the San Diego County Bar Association, the New Lawyers Division, CLA's real property section. So I definitely have been involved in as many organizations as possible. And over the years, developing those relationships and those networking connections, while that might not be an immediate referral source, they've definitely given me traction and credibility, and people trust their referrals to me now. So I do absolutely think that that played a big part in some of my success.
And so Ashley and I are very similar. So I was in the Alameda County Bar Executive Committee. I do it in Contra Costa. I do it with CLA, California Lawyers Association. And also, I've met really good colleagues and friends through it. So maybe, again, there's no immediate impact, but long-term, I think it's been a great way to establish my business.
Yeah.
Thank you both.
So then there's these options for ways to, when you're starting your practice, what types of things you can use. I personally use MyCase and I love it. It's my case management software. I think it's about, I want to say it's about $44 a month. And it's super amazing. It tracks all my time. It logs time to client matters. It sets reminders for dates. You input all your client information in there. You can create invoices in there, submit payment through the invoices. I think I pay 3% on any credit card transaction, which I just take that hit and in order for clients to be able to pay faster. And that's certainly been a benefit for my practice. So yeah, so I use MyCase. I don't use the other ones. Do you use Clio, JR?
I do not. I mean, so I use kind of a mishmash of things together, like QuickBooks. I use that for all of my kind of timekeeping, accounting, invoicing, things like that. And then, so it's like Clio you can store files up there, like your actual files. I don't know about MyCase. I think MyCase has that too, where you can store your files up there.
Yeah, it's like unlimited document file storage and stuff. It's pretty amazing.
So I do use a cloud. I use Dropbox for my files, and it has a lot of flexibility. I like that. I'm continuing to use that. But so I use kind of a mishmash of different things.
Yeah, and I think LawPay just entered into an agreement with CLA. So I think there's a discount for members through LawPay also if people are wanting to accept credit card payments with that company. So that's another option. And then there's obviously legal research tools, which FastCase is another one that's included with your CLA membership. So that's it's an equivalent of Westlaw, basically, or LexisNexis in researching cases and things. So I use Westlaw just because I have access to all the Rudder guides through my Westlaw account, which I use quite a bit. And then I pay for CEB, Real Property Library, and I pay for
you do the business library there?
I do also, yeah. Mm-hmm. And those are great for template forms.
I use both of those. In fact, yeah, I drew up an operating agreement, and I use the CEB to help me guide me through that. CEB has been a great investment. Westlaw, you can't get around using either LexisNexis or Westlaw. I mean, I haven't used FastCase extensively to know. So.
Yeah, same here. It's pretty new at least for CLA, so I have not been exposed to it yet, but I've heard very good things. So, sorry, go ahead.
Well, so the car zip forms, I see you listed that. Like I have that as part of being a broker, and they're good, and there's more to add onto that. There's the air lease forms. There's a lot of other forms that you can add on to that, which are really useful. The car forms, actually, Neil is one of the main people who helps develop all of those forms. I mean, they are amazing. Like, you just ask a question, there's a form about it. I swear there really is. It's they do a tremendous job at CAR developing forms.
Yeah, our forms book is getting a little bit heavy now, though.
Yeah.
I can imagine. I mean, there's so many forms when you download it. I mean, I do a lot of residential stuff, so it's very helpful for me just because a lot of times brokers on the other side will not use anything other than the CAR forms. So even if I have my own templates that I like to use, they will not use those. So it becomes a lot easier to facilitate those residential transactions.
Well, for example, like the option to purchase, that's in there. I prefer to use my own form for an option to purchase because it had the one that is provided by CAR has everything in it, but I don't want everything in there. I just want, So
yeah, and options to purchase are so tricky. So it's like using a standard form for those is not really gonna work so well. But the residential purchase and sale agreements, the residential leases, those are really, really helpful forms to use. And in fact, I'm doing a seminar on the residential sales and those forms next week. So hopefully you all can attend that seminar.
Okay,
on
so Ash, what was the one cost or regular cost that you did not expect to be so dramatic when you went solo?
Honestly, like I have to have landlines in my office. So my phone bill is like $200 a month. It's like crazy. I'm like, this is insane. And it's through AT&T and I can't change it because my building only has AT&T wiring. So it's really ridiculous.
That's too bad. For me, it was renting an office. I think a lot of people that try to go solo try to stay home. And I think that's a mistake. Honestly, you need a place that's away from home. It's not, you need the credibility of having an office, a meeting room. Even if you're in a, what is that called? Executive suite or something like that. It's much better than working out of the house. I've seen a lot of solos working out of the house. Maybe in COVID it was normal, but I think my advice is to get your own office.
Well, I think people with families and stuff, if you have kids or dogs or whatever, things that are distracting you, it makes sense to have an office, because I can't get anything done if I have people distracting me all day. So for me, having the office it's also a nice separation of work and home. But I've honestly been working home more days a week now than ever before. So
wow, cool.
That's just because it's a time saver.
Yeah.
Neil, you can go up the next slide. So then we have a bunch of just resources here for any of you if you're interested in going solo or want some more options to look at for things. There's sample fee agreements through the State Bar's website, which are pretty awesome to use as a template. They have information on how to set up your IOLTA accounts and how not to do anything that's going to get you disbarred with your IOLTA accounts. So I definitely don't touch mine. I treat it like the Holy Grail. And I hardly ever, honestly, in my practice, I don't take a lot of retainers up front. So I don't do a lot with my IOLTA, but I'm sure in litigation and stuff, JR, you probably do.
Yeah, all the time. Yeah. Big deal.
And then obviously like staying up to speed on the California rules of professional conduct, all the advertisement and marketing.
You just
Sorry,
got there.
they're air blowing outside my door, sorry. And then there's solo and small firm resources through the SDCBA, the California Young Lawyers Association, and the ABA there also. So it's just some additional resource links and options for anyone thinking about going solo.
Cool. Thank you, Ash.
Thanks, JR.
Hey, well, great interview, the two of you. I liked the way that was done. That was really good information. Very helpful for someone like me who's been an in-house attorney basically my whole professional life. So it's nice to hear how different people do different kinds of jobs. So thank you very much. And hopefully our listening audience found that helpful as well. So let's kind of wrap up. We got about 20 minutes left. We'll discuss a couple of cases and then we'll see, what's going on, what's up with us. So let's go into those right now. And this one is Cow versus Joy Holiday. And I read the name of the case. And I'm like, wow, Joy Holiday. I started reading the case. I was having difficulty to figure out, like, who is Joy Holiday? And Joy Holiday is the name of the company. It's the name of the corporate entity that, as you can see in the facts, they conduct bus tours in the US and China. Joy Holiday is co-owned by Jesse Lin and Harry Chen that happen to be spouses. They hired an employee from Taiwan, brought him over to the United States. He actually lived with the couple for most of the 2+ years that he was working for them, shortly before he moved out in 2011, or shortly after he moved out in 2011, he was let go. Kao was working a lot of hours. As you see there, he was working, according to the opinion, over 50 hours a week. And there was some language there that sort of indicated the expectation was he was going to work like 20 hours a week. So way beyond, right, what he was expecting to work. Kao apparently, thought, well, I was not paid. Talked to somebody, and he wound up suing Joy Holiday, the entity, and Lin and Chen for violations of federal and state wage and overtime pay laws. He wound up being successful at trial. Look what he got, close to $500,000, right? The basic damage is $110,000, interest almost $100,000. So there you have what, $210,000, $265,000 in attorney fees. So that takes you up to what, $475,000. And there was, I don't know, there was somewhere, I think, close to $10,000 in costs and expenses. So wow, close to $500,000 total judgment against the defendants. Well, the judgment went against all of them, the entity and the individuals, saying that the individuals were really alter egos. And so I wanted to point out to them, because we were talking about small firms, and of course, Ashley and JR's, they said they are acting as sole proprietorships, but there are LLPs. I know there's other structures for setting up law firms. So I just want to make sure when we're talking about that, let's make sure that if you're doing that, if you bring somebody on, right? JR now has a full-time employee. Maybe some of you who are thinking about going solo, you figure you may want to do that because maybe technology can only get you so far. And maybe you don't have the breadth and the depth and the scope that Ashley has to be able to just do it all, right? So you might need some assistance, but you want to make sure that if you are setting up some kind of an entity, you don't fall into the same kind of a trap, right, that the co-owners of the Joy Holiday business wind up. So this case, a good reminder of, what kind of factors go into whether you can pierce through the corporate veil. And I have to tell you, as I was looking for graphics to put up on the screen, I realized, man, there's like nothing I can use, because we live in a very sensitive society these days. So I'm like, forget about that corporate veil anymore. You're popping the balloon or you're pulling the mask off. There we go. I think I'm safe with our two graphics that are up on the screen now. Shouldn't be getting anybody in trouble with those. I'm hoping not. But what are the issues you're looking at for alter ego? Well, is there a unity of interest between the individuals and the entity so that there's really no separation between the corporation and the individuals? And whether adherence to the fiction, right? Because a corporation is a fictional entity. Would adherence to the fiction really promote fraud or injustice? Pretty, open-ended there, right? And then there's a lot of factors that are considered. Every factor does not have to be involved, right? But these are the factors to be considered. Is there commingling of funds? Are you treating the corporation assets as your own? Failure to maintain adequate records. I know I had a business several years ago. It was not a law business, and I had difficulty maintaining my records. So I was very glad when I got out of that business, glad I had no problems, because I had some exposure because I had difficulty maintaining my records there, right? Is it sole ownership of stock by an individual or a family? Is the corporation really nothing more than a shell? Is it being used to conceal, right, personal business activity? And is it a subterfuge? And when this case went up on appeal, the court said, in this particular case, the evidence supported the finding of the trial court. So, Ash or JR, any information or insights you have on
Well, yeah, I
alter
mean,
ego?
commingling of funds is usually the biggest one that gets people into hot water, because they start, putting their personal assets into the business and taking business assets out and vice versa. And that's a sure way to lose that liability protection that the corporation gives you, and also maintaining corporate documents. I mean, people have not done corporate meeting minutes for years and years and years. And I'm like, this is, one of the reasons they can take into a factor of subjecting you to personal liability. So I advise all clients, to make sure they stay up on those things and are careful with what they do.
And so, Ash, you mentioned, I mean, again, you're a sole proprietor, but you have an accountant. So, but if somebody was not a sole proprietor, they've got to really be careful about money that comes in and money that goes out, that you have separate accounts, right?
Yeah, I mean, even as a sole proprietor, I have a separate business account and a business credit card, and I don't do any personal stuff on that because, that obviously you could be subject to audit and things like that. So I definitely am very careful about keeping my business accounts separate from personal.
Chair, something you want to add? I see you nodding. Maybe you're just in agreement. That's all.
Yeah, I'm in agreement. I mean, Ashley touched on the two major things: is commingling of funds, not having separate accounts, and basically using your business as a piggy bank. If you give yourself a salary, or if you have some sort of, again, arm's length relationship with your business, the better it is, and the less you are, doing things with your friends and trying to pass that off as a business expense is just not, it's not going to work.
Okay, and that takes a real mindset, right? Because people who have a small business or a solo business, it's difficulty to separate them in your own mind. And I think if you're going to do this kind of thing, you have to go in with the mindset, I'm going to treat this as a business, right? And kind of break away that there's no difference between me and the business, or the business and me. So it may be more of a mental thing even than a functional aspect. Okay, so let's just real briefly, we're going to talk about this other case that I thought was interesting for those who are involved in real estate. Chu versus Old Republic just came out a couple of months earlier this year, January of 2021. Purchasers of a condo, they did what so many purchasers do these days, which is they buy a home protection plan. So if something goes wrong with, usually it's, an appliance or something like that, or a system in the property, that the home protection company, in this case it was Old Republic, would send out a worker to fix it. There may be a small fee for that as well. Well, here it was the HVAC system that was broken. A repair person came out, supposedly fixed it, but did not match the condenser with a compatible system. The system continued to leak Freon. The owner continued to have problems, whether it was heating or whether it was air conditioning. After several unsuccessful attempts to correct it, they said, forget it, I'm just going to hire somebody to fix it myself. Spent $8,900, wound up suing Old Republic for breach of contract, right, based on the home protection plan that was in place, negligence, bad faith, and unfair competition. Well, Old Republic actually demurred to all the causes of action. The two that were talked about in this opinion dealt with bad faith and the unfair competition law claims. And the trial court said, well, guess what? Old Republic is not an insurer, so those claims are not applicable, and therefore they cannot stand. Those claims were dismissed. The appellate court had a kind of an interesting discussion about this. I said, well, breach of contract is the appropriate remedy, right? In this case, tort remedies are only allowed if there's an exception. There is an exception for insurers, but the court said there's a reason for that. Insurers are basically in a fiduciary position to the insured. That's a very different type of relationship from a home protection company to a person who hires a home protection company. They gave a few reasons that the contracts are really not one of adhesion. You don't need to get a home protection plan as part of a purchase. Sometimes even the seller is the one who's providing that for the buyer. That sort of depends on the marketplace. There's plenty of competition here. There's really no unequal bargaining position. Whereas an insurer has a duty to defend a home protection plan, there is no obligation of the company to do that. And there was legislation that came into effect that said, well, in order to keep this industry alive, it's going to go out of business unless we set up some kind of regulatory process here. That regulatory process went through the Department of Insurance, but that does not make a home protection company an insurer, and we want to keep that business alive. So again, those some people call home protection plans, some people call it home protection insurance. It's really not insurance. This case makes that explicitly clear. Okay, nothing else. We're going to go on then.
Yeah,
Yep,
cool. Thank you, Neil. That was that's important. These details in the real estate purchase agreement are really important, and thank you for touching on that.
Yeah, you're welcome, Chair. So why don't we let one of the two of you pick up about what kind of events we have coming up through RPLS or the CLA?
Go ahead, JR.
Well, Saturday, we have Kelly Corder doing another yoga class for us. It's from 9 to 10 a.m. on Saturday, and I really enjoy that. If you got the email out today or yesterday about, or was it today, about what's up with us, you would have seen the Kelly Corder sign up for that. It's on the CLA website, as are these other ones. Ash?
Yeah, hope you can join us for the yoga. March 24th is my seminar, The Avoiding Legal Pitfalls When Handling Residential Purchases and Sales. I'm speaking with Elva Harding, Renat Ehrlich, and Jose Mendoza, and we'll be talking about it from both the transactional and the litigation side, where things go wrong in the contracts. So should be a good seminar. I'm looking forward to it, and that's next Wednesday.
And don't make the mistake I have. When I tried signing up, I realized my password is no longer good. So don't wait until the last day, because maybe you'll have the same problem I have. So I have to change my password, or I probably did change it at one point and I didn't write it down. So make sure you do it early in case you're kind of sloppy like me and lost your password to be able to sign up for these things. Okay, I'll do the next one. The next one is dogs in the workplace. Very interesting. I've actually seen a similar program that was made by the same person here. Tips for drafting commercial leases, how to address them, why people are doing them, how they're addressing them, how they're addressing problems, with not just dogs, but animals in the workplace. And who's doing that?
Joanne Woodson.
Yeah, Joanne.
Thank you. For some reason, her name slipped my mind. Like I say, I saw her do a similar presentation. It's really, really great. So anyone who's involved in commercial leasing really wants to attend this. You're seeing a lot more of this kind of expansion of the workplace, kind of almost an extension of the home, right? Home have become extension of workplace. Now that we're getting maybe a little bit more back to normal, the workplaces have become more like an extension of the home. So these issues, I think we're going to find more and more. Next.
April 8th, we have a Community Association HOA legislative update. There's a lot going on in that arena. We've talked about that before in our WUWU or What's Up With Us presentation, so that should be a good one. April 13th, SB 91, extension of COVID relief. Do you know who's teaching that? I mean, that's a really hot topic. I'm sorry?
I think Anna and Rachel Callahan and Lawrence Mudgett, I think.
So Anna and Rachel are two people that have extensive knowledge about landlord-tenant law, one from Northern California, one from Southern California. I don't know the other one, but that class is going to be a don't miss. And
right.
Then of course, every month on the 10th of the month, if you want to submit an article or anything to our e-news, you can get it to us. And actually, you can email it directly to me. I guess we'll give my email later on. Any of your articles or ideas.
Give it right now, JR.
It starts with the letter J, and then it's jrichards@richards-legal.com. Very long. jrichards@richards-legal.com.
And the e-news comes out every month. They accept submissions no later than the 10th. And we're not talking about a 30-page article that would appear in our Real Property Journal. You know, it could be a couple of paragraphs, it could be a page. That's the kind of thing you're looking for, right, JR?
That's right, Neil. In fact, we had a really good one from Monty McIntyre. It was just a paragraph long this month, and it was featured in this month's e-news.
Okay, great. So I'll just something, to think ahead. Last year, the Real Property section, in conjunction with many other CLA sections, was going to have a cannabis symposium in conjunction with its spring conference. Of course, the conference got canceled last year, as everything did last year, but we're bringing back the cannabis symposium, but virtually and in a series. So over the course of 3 days, you can see the different topics there. Cannabis is really becoming, kind of all encompassing in California society, whether it's a residential sale or a commercial sale. That comes up a lot. How do you handle money? How do you deal with regulators? A lot of stuff that you need to know. And again, maybe some of these interest you, some of you don't, some of them don't, but the way it's broken up, really nice for this summer to pick and choose those sessions that you want to know more about. Hey, what else? What's up with us? Well, again, I'm not seeing any comments so far. I was able to figure out how to open my chat box. Our next What's Up with Us, Thursday the 15th at 12:30 as usual, and be there with us cool kids.
Are those pictures supposed to be cool kids, Neil? Is that what that is?
Yeah, that was the best I could find on short notice. I wish I could find leather jackets on them, but I couldn't find them like that.
Yeah.
So.
All right. Well, thank you all for joining us today. We hope to see you soon.
And we really appreciate the interview you had with each other. That was really great. Great stuff.
Yeah, great. Best interview yet.
Bye, everybody. See you next month.